Welcome to the Supreme Court, where we are hearing the appeal in the case of Manchester Building Society and Grant Thornton, which is concerned with the correct approach to quantifying damages for professional negligence. We're hearing at the moment submissions on behalf of the Building Society, and I'll invite counsel, Ms. Sabin Clare, Queen's Counsel, now to continue.
Thank you, my lord. So I just reached my third point of my legal submissions, which is that what a focus on the nature of the defendant's duty does do is point you to the question, did the right thing cause the loss? In other words, did the breach cause the loss? Before we took a break, I took you to Lord Hoffman's discussion of the mountaineer and his knee, and showed you there that the right thing did not cause the loss. The loss was caused by the rockfall, not the doctor's advice. Similarly, in Samco itself, it was held that the right thing had not caused the loss over and above the extent of the negligent variation. I want to take you next, please, to BPE and Hughes, which is the case from which I have borrowed the words, did the right thing cause the loss? And that is, I'd like to go, please, to page 1260, first of all, please, in the electronic bundle. So here at paragraph 11, you see an account in Lord Sumption's judgment of the issue about whether if the £200,000 had been spent on the development, it would in fact have enhanced the value of the property. And he explains there that BPE's case was that the loss arose from Mr. Little's over-optimistic assessment of the likely cost of the development. And he says that at letter F now, that the case was that the cost would have been greatly in excess of £200,000, with the result that when the money ran out, the development would have been left incomplete and the property unsaleable. And they say that Mr. Gabriel would therefore have suffered the same loss even if the transaction had proceeded as he had been led to expect. Now, the transaction there was a loan from Mr. Little to Mr. Gabriel. So the loss was the non-payment of the loan. So the question was whether Mr. Little would have suffered the same loss on non-reimbursement on his loan in any event. And over the next paragraphs, there is an account of the difficulties of the development, which culminate in Lord Sumption's conclusion at paragraph 19, that in his judgment, irrespective of the incidence of the burden of proof, the Court of Appeal was entitled to find that the expenditure of £200,000 would not have enhanced the value of the property. It follows from this that the factual basis of BPE's case on damages is sound. So what had been found over those paragraphs is that the proposition that it was a good idea to invest in the development of a disused heating tower on an airfield was a fantastically bad idea. That's what the trial judge had found, and that is the conclusion that Lord Sumption is recording here. And therefore, in that case, the very same loss, namely the non-repayment of the loan, would have occurred in any event. Now, if I can jump ahead to respond further to Lord Borough's question this morning, what we say is that paragraph 53 of this judgment at page 1277 has to be read in light of that finding of fact and in light of the test that Lord Sumption then goes on to pose, which I'm going to deal with. What he says is that the effect of the practical effect, and I'm reading here between letters C and D, the practical effect of the principle formulated in Samco in cases such as these is to limit the amount of damages recoverable in respect of loss flowing from the claimant's decision to enter into a transaction. Then he says it's an essential part of the claimant's case that he was owed a relevant duty. Now, our submission is that all that means is that the claimant has to show that he is owed a relevant duty, and at most that he would not, in a case where Samco applies and is relevant, that he would not have suffered the very same loss. Now, we say our case is not like that, and that's not what we're concerned with. But if you were against me on that submission, and you were to find that Lord Sumption was there saying that something more extensive had to be proved, then I would be challenging that, and that would be implicit in my appeal. So I'm sorry if that's a rather more complicated answer. Maybe it's less complicated, but it's at least a further and better answer to Lord Burroughs' question this morning. Now, coming back to the test, at page 1270, at between letters G to H, Lord Sumption said 3 lines down, if the Samco principle is to be classified as a principle of causation, it's certainly not directed to that question. That's a question about but-for loss. And then he says, the question which it poses is rather whether the loss flowed from the right thing, i.e. from the particular feature of the defendant's conduct which made it wrongful. So my submission is that that is the rule of law that he's identifying here. And I submit that it is in practice one and the same thing as a test of sufficiency of cause. That much was actually said by Lord Justice Evans in Anaco. If we go now, please, to page 974 of the bundle. I'm taking you to Lord Justice Evans' judgment in the Court of Appeal in the Anaco case, which was, of course, about the placement of reinsurance cover and the question whether the claimant could recover all of the loss through entering into, I would characterize as a business model, a series of insurance treaties, or only the recovery that would have been made under reinsurance. And in paragraph 20, Lord Justice Evans says this. He says that the authorities mean that the former search for an effective cause has been replaced by an inquiry into the scope of duty of care. Then a few lines down, he picks up Lord Hoffman's words, which I've also drawn to your attention, that relevant considerations are whether there's a sufficient causal connection. And then he says in the last 6 lines on this page, he is only liable for that part of the loss which is regarded as a consequence of the information or advice being wrong. The link is only established if there is a sufficient factual connection between the loss in question and the wrongness of the information or advice. And then in the next paragraph on the next page, he cites Royal Greek Government and Minister of Transport and Mr. Justice Devlin's judgment in that case. And he says in the last few lines of this paragraph that he doubts whether the redefinition of the legal concepts materially affects either the substance of the question or the range of factual matters which is relevant to the answer. And that we submit is again correct. And for your note, at paragraph 39 of his judgment, Lord Stein said that whilst Lord Justice Evans' conclusions were in issue, there could be no valid criticism of the remainder of his judgment. Lords Slynn, Brown, Wilkinson and Lloyd all agreed with Lord Stein in this case. Then lastly, on this point, the Levent case at page 1129 of your bundle, this is a Canadian authority, Canadian Supreme Court decision. And you'll see, as this may be less familiar, I'm starting by taking you to the head note at page 1129, that the claim was an audit negligence one. Deloitte had failed to uncover a fraud, And instead, and I'm right at the bottom of the English on page 1129, they'd approved a press release which misrepresented the basis for reporting of the profit. They provided a comfort letter for a public offering. And it then also prepared the 1997 audit. The trial judge had awarded damages of over $84 million. The majority cut that down in this judgment to 40 million, holding Deloitte liable for losses flowing from the audit, but not from the IPO. If we go to the majority first at paragraph 90, which is at page 1177, the court says there, and this is, as I said, a majority judgment. 4 out of the 7 judges agreed to this. They say, in simple terms, the Samco principle denies recovery for pure economic loss where the plaintiff's injury would still have occurred even if the negligent misrepresentation were factually true. Rephrased as a test, the principle denies liability where an alternate cause that's unrelated to the defendant's negligence is the true source of the plaintiff's injury. And we submit that, again, that is right in looking to cause. The test is cause. Much the same point was made at paragraph 140 in the minority, now at 1195. In paragraph 139, the judgment identifies that there are doctrines of scope of duty of care and of remoteness. And at 140, they say that though lawyers may argue about which approach is preferable, they're two sides of the same coin and invoke similar considerations. And in 141, that the scope of duty of care inquiry looks to the relationship between the defendant's advice and the plaintiff's loss. It asks if that relationship was proximate. And then they say about 2/3 of the way down that paragraph, put simply, did the loss flow from the advice or from subsequent decisions and circumstances? It's the same thing. So, my lords, we say that there is a lot of authority, including at the highest level in England, to the effect that the real test is one of sufficiency of causal link. So I come then to my point 4, which is that the Samco information analysis and the Samco cap simply cannot stand as a hard and fast rule of law. I've already made my submission that in fact these authorities are not purporting to set out such a hard rule, but were they to be so interpreted, that would be wrong in our submission for the following reasons. And I should preface this by saying that there has, of course, been much academic criticism of the decision in Samco. That includes the article written by Lord Burrows, which you'll find at page 1323 of your bundles. I espouse the points there made as criticisms of the decision, but I'm not going to take you through each point in the article itself. My points are these, and I'm going to label them A to E to avoid confusion with my main points. A, what would have happened if the information had been correct is not the measure of damages for breach of a contractual obligation to take care, or indeed any form of contractual obligation other than a warranty. That point has been pointed out by Lord Burrows at pages 1332 to 3 of the bundle. The same point has been made by Professor Stapleton in her article, which you'll find at the next tab. As both those authors say, there is no warranty paradox, as Lord Hoffman saw it. The starting point is that the victim of a breach of contract is ordinarily entitled to be put in the position that they would have been in if the contract had been performed, subject only to the filters of causation, factual and legal, and remoteness. And it is notable, my lords, that although Lord Hoffman started his speech in Samco by saying that the measure of damages is the wrong place to start, Where did the court start in NICredit when it came to apply the judgment? With the measure of damages, the basic loss. And the same point, the same approach was taken by the House of Lords in Platform Homes and Oyston. The starting point is necessarily the contractual measure of damages in our submission. B, there is a problem that there are cases where applying the Samco cap palpably gives the wrong answer. Lord Burrows, in his article at page 1335 of your bundle, gives the example of a client who's wrongly advised by their lawyer that they're barred from developing a product because it would infringe profits, because it would infringe some copyright or intellectual property right. Clearly, absolutely clearly, the client has there suffered a loss in the amount of the profits that they would have made if they had not been misadvised. But the apparent of the Samco cap is to ask what position they would have been in if the information had been correct. If the information was correct that they couldn't develop the product, no profits. It doesn't work. We give an equivalent example of negligent advice which fails to draw the client's attention to an available tax provision which would reduce the tax payable. In that scenario too, the position is exactly the same if the advice had been correct. The client would pay precisely the tax that it was told it had to pay. Mr. Salcido seeks to answer that at paragraph 76 of his case by saying, well, there's an asset which is the right to collect in the asset of the overpayment of tax. That's quite fantastically convoluted, defies common sense, and it's just not right. There's plainly a loss incurred at the time you pay too much tax. My third example is dividends, but I'm going to deal with that in a moment when I take you to the BTI case. Point C, the distinction between advice and information, or worse, category 1 and category 2 cases, is an unsustainable one. And we make that submission, my lord, because entering into a single transaction as a result of a single piece of negligent advice is merely one of the myriad forms of professional negligence. In very many cases, the breach of duty cannot easily be pigeonholed into one or other scenario. So, for example, in Anaco, at paragraph 16, Lord Stein pointed out that the broker's breach of duty could equally be put as a failure to report that reinsurance was unavailable. What's that? Advice? Information? How does it work when you ask what would have happened if the information had been correct? It is neither information nor advice, and the cap can't sensibly be applied to it. I'm also going to come on to say that that point is well illustrated by the audit cases, which I'll take you to. Point D, Samco addresses a single transaction scenario. That's the language in which it's couched by Lord Hoffman. How does it work in a more complex case? It becomes extremely difficult to apply. For example, in the present case, what is the transaction? The advice went to the question, can we apply hedge accounting in the preparation of our financial statements? So why shouldn't the transaction be the preparation of the financial statements applying hedge accounting? If so, it follows that all consequences of that advice being wrong are recoverable. A distinction there has to be drawn between to identify what is the transaction. Why should it be the swap transactions as is assumed by Grant Thornton's case, rather than applying the accounting itself? My point is that the language just isn't capable of sensible application to a more complex scenario. My point E is that the law on losses should be back to back with the law on gains. They ought to be equal and opposite inquiries. They ought to identify the same matters as legally relevant. this court has recently reviewed the law on gains. It did so in the Thornton shipping case. I want to show you, please, Lord Clark's judgment in that case at page 194. So in this case, the court was considering the damages position following the repudiation of a charter party. And because a vessel had been redelivered early, the owners had sold the vessel and they had received more by way of capital value for the vessel than they would have done had the charter gone to its completion and the vessel then been sold. And the question is whether the value of the sale fell to be taken into account in the assessment of damages. And this court held not. And at paragraphs 29 and 30, Lord Clark said this. First, in paragraph 29, viewed as a question of principle, most damages issues arise from the default rules, which the law devises to give effect to the principle of compensation, whilst recognising that there may be special facts. And he says on the facts here, the fall in value was irrelevant because the owner's interest in the capital value of the vessel had nothing to do with the interest injured by the charterer's repudiation of the charter party. Paragraph 30, this was not because the benefit must be of the same kind as the loss caused by the wrongdoer. And then he agrees with the trial judge, Mr. Justice Popplewell. And he says, as I see it, difference in kind is too vague and potentially too arbitrary a test. The essential question is whether there is a sufficiently close link between the two and not whether they're similar in nature. The relevant link is causation. The benefit to be brought into account must have been caused either by the breach of charter or by a successful act of mitigation. So in that case, Lord Clark was rejecting a more technical rule, the idea that the gain had to be of the same kind. And he was saying basic rules apply, and the rule for identifying relevant gains is sufficient link, sufficiently close link, which is a causal link. And my submission to you is that the filter to identify legally relevant loss must be the same, must be back to back with that. I just want to mention in that context, Needler and Tabor, which we've also included in your bundle. I'm mentioning this because it's a more directly comparable case on the facts, because it's one concerning a professional's breach of duty. In that case, Mr. Needler had received negligent pensions advice, which meant that he had a pension with Norwich Union, which he ought not to have done. But because he held a pension with Norwich Union, he benefited from the bonus when it demutualised. And so the question was whether that bonus fell to be taken into account. And there too, the court's approach was one of causation. The reference is paragraph 26 of the judgment. There is not a whisper in the decision of scope of duty. That was a, yes. So, my lords, for all those reasons, we say that the SAMCO information advice divide and the cap that follows from the information analysis cannot be a black and white rule of law. My point 5 then is to develop my narrow case that even if SAMCO applies, it's not necessary for a claimant to prove that it would not have suffered an equivalent loss at some other time if the professional's advice had been correct in order to claim damages. The normal position is that the burden of proof is on a defendant to prove that the claimant entered into a bad bargain and so should not be awarded damages. That proposition is stated by Mr. Justice Tier in the Momola Challenger, which is in your bundle at page 2039, and it's paragraph 47. His point in that case was that wasted expenditure is a species of expectation damages. And he said that the burden of proof to demonstrate that there was a bad bargain and that therefore wasted expenditure shouldn't be available as the expectation measure must be borne by the contract breaker. Now, that proposition was explained by Lord Burroughs in his book, Remedies for Torts, Breach of Contract and Equitable Wrongs. And I do just want to take you to that, please. That's at page 1327. And so this whole section of the book has been dealing with the rules on wasted expenditure damages. It refers to the Momola decision that I've just referred you to, and to one Mr. Justice Leggett's judgment in the Yan Seng case to the same effect. And then at the top of page 1327, Lord Burroughs says this. He says that it may at first sight appear puzzling why the courts are willing to give the claimant a benefit of a rebuttable presumption that it made a good bargain. But it's submitted that this is simply a consequence of the fact that the defendant is a contract breaker. It is as a result of breach by the defendant that one does not know what the position would have been had the contract been performed. It is therefore only fair and proper that the problems of proving what the position would have been had the contract been performed should fall on the contract breaker and not on the innocent claimant. And in our submission, all of that is absolutely opposite to our case as well. Because Grant Thornton broke its contractual obligations, it is not known what the position of the society would have been in 2058, taking into account whatever would have happened under the swaps by then. And one thing we can be sure is that the forecast would have been wrong. And whatever had happened by way of fixed rate earning by that point, so the lending under the mortgages. It's not known, tomorrow never came because of Grant Thornton's breach of contract. It must be Grant Thornton's burden of proof to establish what would have happened. So these counterfactuals, 2058, 2077, 2099, in our submission, they were Grant Thornton's burden of proof. And if that was incapable of proof because of the uncertainties, that is a consequence of the breach and does not make the basic loss, which had been proved, irrecoverable. Now, this is a convenient place to deal with Lord Justice Mayall's point in the Court of Appeal in the present case, which Lord Justice Hamblin referred to in paragraph 86 of the judgment. He said there, well, what about the case if the outcome had been known on the swaps because they were of a 5-year duration? Surely that would have fallen to be taken into account. Well, my answer to that is, if only the swaps had been of a 5-year duration, because then we would have known by the time of the trial not only what the outcome of the swaps had been, but also what the income would have been. And in those circumstances, the burden of proof wouldn't really matter very much. It would be known what the outcome was, and whatever it was would be available to be deployed as an argument on effective causation. That hypothetical proposition, it doesn't answer the question, whose burden of proof is it as a matter of principle to establish whether some other loss would in fact have been suffered in due course as a result of pursuing this business model. I would add one more observation to that. Still these counterfactuals. The search for what would have happened distantly into the future of itself brings into play all sorts of matters that the court would ordinarily consider legally irrelevant. By 2058, there would be issues about what the result on completely unrelated parts of the business had been, and therefore what capital was available for new mortgage lending, by way of example. None of that would ordinarily be regarded as relevant. So in my submission, the fact that this test, as posited by the Court of Appeal, takes one onto an impossible inquiry into legally irrelevant matters is the clearest possible indication that this can't actually be an inquiry that's required by the law at all. I come back to my primary point that the test is one of causation. Yes, Lord Burrows.
So just so I fully understand, as I understand what you've said this afternoon, I think you are challenging the proposition that was put forward on the face of it by Lord Sumption in the BPE case. I think you are challenging that the burden of proof in relation to the Samco cap should fall on the defendant. You've recast this as a matter of legal causation, but you're saying effectively that the burden is on the defendant, as I understand what you're now saying. The second point, however, is assuming that that is correct, that the burden of proof is not for you, but is for the defendant. Why isn't it the case that the market has told us the answer to the question by putting the fair value of the swap at the whatever it is, 35 million? That is the market evaluation which the claimants are able to put forward to meet their burden of proof if they have that burden of proof. Sorry, that the defendants have to meet their burden if they have that burden.
It doesn't meet the point because it's only one part of the picture. So I remember I started by showing you the arrows diagram, and it is only showing you one of the three entries on that diagram. There's the maybe I should say two. There are the lenders and there are the swaps. It's telling you that it can be put forward as evidence of what might have been paid in future under the swaps, but it tells you absolutely nothing about the top left of that diagram, which was the mortgages. So it's not sufficient in my submission to deal only with one side of the coin of the swaps. It's quite wrong to look at these in isolation. This was a business model. Yes, I think Lord Leggett had his hand raised first.
Does it not come back to the point I was raising with you this morning that because the mortgages didn't last the same length as the swap, that there was, as I understand it, the fair value of the swaps took account of the expected future performance of the swaps over the rest of the 50 years. Yeah. When the mortgages are sold, they will only take account of the expected future value of the mortgages for however long they're expected to last, which isn't as long. But what the society was expecting or hoping to do was to replace mortgages so that over the duration of the swaps, it would continue to earn more income than it was paying out under the swaps, in effect.
Exactly.
And you're saying that it shouldn't be for you to have to prove that that would have happened. It should be for the defendant to prove that it wouldn't have happened.
Yes, my lord, that's exactly right. And furthermore, I can also say and do say that in a world in which Grant Thornton's advice had been correct, there would have been more mortgages, because the basis of their advice was, number one, there would have been substitution in of new mortgages, and number two, that hedge effectiveness was expected prospectively. They said they were satisfied at the time of each audit that hedge accounting could be applied, and that meant that there had to be prospective effectiveness. But yes, that's right. I agree with the way you put the point.
I'm afraid I still don't understand why you're going on about the future performance of mortgages. The damages that you're seeking to recover are the break costs, the costs of terminating the swaps contracts in 2013.
Yes.
Right. And you characterise that as a loss because you say that was a negative figure, and we've no way of knowing how reality would have turned out if the contracts had run their full course.
Yes, but
and the answer to that point is the one that Lord Burrows just gave you, that the future performance, the best evidence of the future performance of those contracts is the MTM.
The break costs are the basic loss. They're a loss that wouldn't have been suffered but for the negligence. In addition, but for the negligence, my clients would not have acquired the additional banks of lifetime mortgages. And at the trial, we had a whole schedule of ins and outs of transactions that wouldn't have occurred but for the negligence. And those are covered in little 1 to little 9 of the judge's judgment under heads of loss. And they include the mortgages as well as the swaps. Now, the question, what would have happened in future, is no part of the basic loss, no part of the question.
Well, I know you're ignoring it. That's the difficulty I have with your argument, that you disregard what would have happened if the contracts hadn't been terminated.
No, my lord, I'm sorry, but that is confused, because if the advice had been correct, there would have been the swaps to the end of their 50-year term, and there would have been the existing mortgages whose value could be and was quantified by the judge.
Yes,
and there would have been new mortgages. And it's the new mortgages that are not part of the MTM losses, that are not part of the MTM assessment of the future position.
I appreciate why, if you get into a SAMCO analysis, you are looking at what would have happened if the advice given had been correct. I have difficulty even getting to that stage. My problem is understanding why you say you suffered any loss in the first place.
Yes.
Why you characterise the break cost as a loss in yes. ordinary damages terms, regardless of SAMCO.
Because, my lord, my clients had to pay that cheque for 32.7 million to exit the swaps.
Yeah. But it was an early, it was an early capitalisation of losses on those contracts that would have been incurred over many years.
Yes, but what my clients lost because of the realisation that they couldn't apply hedge accounting was the opportunity to earn equal income in the future. But, my lord...
if you can make that good, that perhaps is a head of loss.
Yes.
That you are deprived of the opportunity to earn profits on future mortgage contracts because of an early termination of your, effectively a future loss of profits claim. But that's not how your case has been put.
No, my lord, the judge found that the 32.7 million was a loss, and he was right about that because it was a liability to pay money that arose, number one, because the client had entered into the swap contracts when it wouldn't have done if Grant Thornton hadn't been negligent. And number two, because once it was appreciated that the advice was negligent, the swaps had to be terminated. So it was a cost. It doesn't matter for these purposes.
It's a cost.
Yeah, it is a cost.
Thank you.
Thank you. I think I've caught up with outstanding questions. Good. So I'm going to move on then to point 6 and the audit cases, which I rely on, as I said, not as some special category of themselves, but rather of illustrating the difficulties with the SAMCO analysis. And can we go first to the BTI case and to page 1833 of your bundle? Again, I'm taking you to the head note because the case is a recent one and maybe less familiar. So claim against PwC, and you'll see at the top of the head note that a company called AWA had some historical environmental liabilities, and it's explained that they acquired an insurance policy in respect of those liabilities. Then at the bottom of the page, at the end of the paragraph, just above H5, you see that PwC approved some interim accounts and declared a dividend in favour, declared a dividend. Then in 2009, PwC, the next paragraph, approved the annual accounts and the directors declared a further dividend. So, as you might anticipate, the question was whether PwC had been negligent and whether damages were recoverable in respect of the dividends. And this came before Mr. Justice Fancourt on a strikeout application. And at page 1861, right at the bottom of the page, you'll see in paragraph 108 that the judge recorded that PwC contends that as a matter of law, loss suffered by AWA is not loss that PwC owed AWA a duty of care to prevent. And there's then a reference to other cases in which dividends have been held to be a recoverable head of damages for audit negligence, and reference to the submission that the decisions were made before Samco, which it said mandates a different approach. And the judge then at paragraph 112 records the basis on which that submission was put by Mr. Salcida, which is an argument that if the accounts in question had indeed shown a true and fair view, then the dividend would have been declared in any event, and accordingly any loss resulting from the payment of the dividend is outside the scope of its duty of care. Now, my lords, we say that that is another one of these examples of cases in which Samco, if literally applied, gives rise to an unacceptable result. Mr. Justice Fancourt said so too. He says in paragraph 115 that it seems intuitively wrong. And he's clearly right about that. It's hard to think of a more obvious example of a head of damage that should be recoverable for audit negligence than the entity relying on the financial statements to pay out a dividend, misapprehending its own financial position. In paragraph 117, the court says that even if one were to apply Mr. Salcido's counterfactual approach, the position would then have been not only that the dividend would have been paid, but also that AWA would still have a positive value and been able to meet its liabilities. Instead, it was left with insufficient assets to do so. So what do you get from this case? In my submission, two things. The first is that in an audit case such as this is, the search for the question, what position would the audit client have been in, if the information had been correct, is a complex one in which it is extremely difficult to draw hard and fast lines. Mr. Salcido made a narrow submission, look only at the dividends position. The judge points out that other assets would have been held. The second point you get is this. This is closely analogous to the arguments that we have here, because the argument that the MTM losses reflect what will be paid out in future, and therefore are a sum that would have been paid anyway, is an equivalent argument to that which Mr. Salcido was advancing in BTI. And just as that was a bad argument, because it ignored the assets the company would have had the advice been correct, his argument here too is a bad one, because it ignores the assets that the company would have had. And in our case, the search for the assets that the company would have had takes one into the future to mortgages that would have been purchased in future, not just those that the company had at the time. So whilst Mr. Salcido's argument that there was somehow no loss in this case, or that what would have happened in future is somehow proved by the MTM losses. My answer to that is no, that's wrong. Number one, there's no loss paradox, as he characterized it at one point. There is a real loss in paying out the 32.7 million under a swap that the society would never have had, but for the negligence. And number two, you draw your Samco inquiry much too narrow, just as you did in BTI. The inquiry must take into account the assets that the company would have had. Now, the second case that I want to ask you to turn to is AssetCo and Grant Thornton. That's at 1016 of the bundle. This is a recent decision of the Court of Appeal in another audit negligence claim. And you'll see from paragraph 22 that the principal heads of loss being claimed in that case were funding losses. So money that the parent company had paid to fund the subsidiaries' activities under the misapprehension that they were profitable. In fact, the whole thing was being propped up by fraud. In paragraph 24, you'll see that Grant Thornton's grounds of appeal challenged the conclusion that the loss fell within the scope of its duty. And at the top of page 1017, paragraph 25, you see more specifically that it was said that the judge had erred, I'm 3 lines down. Ground 1.2 is that the judge erred in failing properly to consider whether trading losses claimed by AssetCo fell within the scope of Grant Thornton's duty and in wrongly aligning the scope of duty and legal causation. At 1018, paragraph 32, you see a long list of allegations of breach of duty, not unlike the allegations of breach of duty being made in this case. Failures to detect a misstatement. I say not unlike in the sense that they're audit allegations. I accept that the subject matter was different in that this was about failure to detect a fraud as opposed to failure to detect that an accounting rule was being applied when it didn't need to be. Then coming on to page 1033, it's that chap, Mr. Salcedo again. At paragraph 84, Mr. Salcedo submits that the Samco principle applies to claims against auditors, including, as in this case, general audit claims, that they're information claims, and it's therefore essential for the claimant to establish that the losses it claims would not have been suffered if the audit reports had been correct. And he goes on to submit that in this case, AssetCo had not asked the judge to find whether the losses would have been suffered if the audit reports had been correct. So the judge hadn't answered that question, hadn't answered it, and they failed to establish a basic and necessary element. And at paragraph 89, page 1034, Mr. Salcedo's submission was rejected, and Sir David Richards said 5 lines down, in my view, the submissions of both parties misstate the purpose of the Samco principle. It is simply a tool for determining the losses which fall within the scope of the defendant's duty. There may be cases in which a claimant can't succeed without specifically alleging and separately proving that the loss would not have been suffered if the information provided by the defendant had been correct. But in Samco and in many others, he goes on to say that the answer is established by the evidence as a whole without any need for it to be separately addressed in the course of evidence. And he says that it didn't matter that the judge wasn't specifically invited by either party to address it. So that was accepting the principle that Samco is a tool and saying that it therefore didn't have to be satisfied in every case. Then at page 103.6, at page 96, the judge accepted Mr. Templeman's proposition that there are significant differences between auditors issuing an unqualified audit certificate and the position of a professional who is just providing information or advice on a particular aspect of a proposed transaction. That's my point, that information and advice is an incomplete expression of the range of professional duties. And then page 103.8, paragraph 101 says that SAMCO can apply in many circumstances, but paragraph 102, there may be exceptions to the principle. And he referred there to Mr. Justice Fancourt's judgment in BTI. And he says in the last 5 lines of the paragraph that it's not a rigid rule of law, simply a tool, and concludes if in a particular class of case it is incapable of achieving that determination, it is not a tool which the court will use. Then his conclusion, so the ratio of this judgment on this point is in paragraph 108, at page 103.9. And he says it's not just a case of but-for causation, and goes on to explain that Grant Thornton failed to detect the dishonest concealment of the substantial losses, and that deprived the shareholders or the non-execs to bring AssetCo to account. In summary, my submission, the substance of that finding in paragraph 108 is that effective cause was proved. There's no reference in it to the SAMCO cap inquiry. There is a reference to the purpose of the requirement for an audit. That is, in my submission, the did the right thing cause the loss test. It isn't applying a SAMCO cap. Just give you one more because of shortness of time, I'm going, if I may, just to make some points briefly to give you references to 3 other audit cases.
I've only just looked at this case just now, but the contrast that is being drawn in the judgment seems to be between a situation where information or advice is given which is used in deciding whether to adopt a particular course of action or to persist in a course of action on the one hand, is not in that category. It's more like the category with which that was being contrasted.
Yes, but that would be wrong, my lord, if that was said, because in the present cases I've shown you, there were also allegations of breach of Grant Thornton's obligations as auditors, which allegations were admitted, and which allegations include ones that the financial statements were in fact materially misstated as a result of the application of hedge accounting. And I showed you this morning the passages in the judgment which explain that once the misstatement was corrected, the society had insufficient regulatory capital because of the effect on its reserves of correcting the misstatement, and that's what caused the loss. So, my lord, if that were to be said, and that is the gist of what the Court of Appeal said in this case, but it's wrong because that's to look only at the, at most that's to look at the April advice, can I apply hedge accounting, without also appreciating that in this case, Grant Thornton had a myriad of obligations as auditors. And just as in Anaco, it was Lord Stein or Slynn, I forget, Stein, I think, said that the brokers had failed to report the unavailability of reinsurance. In the present case, the auditors failed to report that hedge accounting could not be applied. And they failed to report that applying hedge accounting misstated the company's financial position. Sorry, society, I keep on saying company. So, my lord, your question is correctly put by reference to the Court of Appeal's judgment. It's the parallel that they drew, but it's wrong.
Well, I thought the significance in this case of the, I may have misunderstood. I thought your complaint about the negligent auditing was that it resulted in the swaps contracts being continued long after they would otherwise have been closed.
That's the but-for argument, yes. And then when one moves to consider the position, what happened in 2013 when it was identified that hedge accounting couldn't be applied, that's when the misstatement is identified, and it's the identification of the misstatement which necessitates the exit from the swaps. The break costs have to be incurred because the society cannot continue to hold the swaps because of their effect on its regulatory capital position and the ongoing volatility to which they expose it. That's what Mr. Harding said in his evidence, which the judge accepted. So just references, and this is to illustrate the range of questions arising from audit cases. Thamesil, page 2071 of your bundle, was a case where the auditors failed to detect an error in the profit margins reported in the financial statements. And the audit client said that its pricing had been based on the false view created by the financial statements. Clearly, if the information had been true, the pricing would have been exactly the same. So there too, one would have to unpick. Well, the analysis breaks down in Sanko terms, it doesn't work. And any attempt to detect, to prove what would have happened if advice had been correct would involve a speculative inquiry into the profitability of the business if correctly represented. Mr. Justice Tomlinson did not go down any of those avenues. It was a strikeout application. He refused to strike out the claim on the basis there were issues for trial. And he said that one of the principal questions would have been the reasonably foreseeable consequences of the negligence. The key paragraph of his judgment is paragraph 60. In Equitable Life, the complaint was, of course, that the auditors had failed to ensure that the financial statements made sufficient provision for the litigation about guaranteed annuities. Mr. Justice Langley struck out a claim for losses framed as loss of an opportunity to sell the business sooner before they became worthless. He struck them out on the basis that there was no evidence that Equitable Life had asked the auditors for advice about the sale. The Court of Appeal reversed him, and the key paragraph is paragraph 129 of their judgment, page 1970 of the judgment. And in the Court of Appeal held that it's no part of the law that you have to ask for advice on a specific point before there could be a liability. But I suggest that in that case too, if you ask what would have happened if the advice had been correct, you go down a blind alley. The accounts would have correctly stated the position in relation to the provision. And then what? Lastly, Livent, I've already shown you the Canadian decision once. at paragraph 87 at page 1176 of your bundle, the majority pointed out that audits do not ordinarily cause harm in themselves. The issue is detrimental reliance. That will, of course, always involve the client acting as it would have done if the advice had been correct. That's the essence of what goes wrong. It's the essence of reliance in an audit case. So in almost every audit case, it will be possible for a defendant to say you're in the same position as you would have been in if the advice had been correct, because the client would have assumed that the advice was correct. It doesn't work. So, my lords, I now made my submissions on the law, and I want to make some brief remarks about their application to the facts, though I suspect that I've covered much of this in the course of my submissions. Oh, sorry, Lord Burrows, yes.
Just before you leave the law,
Yes.
You've recast Samco as a case of legal causation, and you're arguing that submitting that's the best way in which we should view it.
Yes.
Now, Mr. Justice Tier looked at legal causation, and he found that there was effective legal causation satisfied.
Yes.
And of course, he also separately looked at Samco. But I mean, clearly, he wasn't seeing the two as one and the same.
No, he wasn't, my lord, and he was wrong in law in our submission by failing to do so. So the only reason that Mr. Justice Tier held that this claim was outside the scope of the duty was that, notwithstanding his finding on effective causation, and notwithstanding his conclusion that Samco did not entail the speculative counterfactual that we've been discussing, he held that there hadn't been an assumption of responsibility because these were somehow commercial decisions for my clients and not an accounting matter. And in that, my lord, he was plain wrong. There was no space, there was no room for that conclusion, having reached the views that he did, both on effective cause and on the Samco inquiry. So,
okay, so on your analysis, there is a clear incoherence in your view, in your submission, in what Mr. Justice Tier was saying. He couldn't on the one hand say effective causation and then on the other say Samco rules out the claim.
yes.
Now, the second point that follows on, back to burden of proof, won't it be useful for you, if your submission's correct, to look at the cases on legal causation to see what the burden of proof has been historically on legal causation? My understanding is that there have been authorities going both ways, but that probably the preponderance places the burden of legal causation on a defendant. But don't we need to be shown those authorities?
Well, my lord, I'm not sure whether there's any particular authority that you'd like to be like me to discuss. There are, of course, myriad authorities on the question of legal causation.
No,
some of them, such as
I'm talking specifically about the burden of proof
yes.
in relation to legal causation.
Yes. Well, my lord, I certainly accept that that is a relevant matter. There aren't any further authorities on legal causation before the court now in the bundles for me to take you to. Of course, if it would be of assistance to have any further submissions from us in writing on that, very happy to provide that. But I don't think there's any further I can take that now on the materials before the court. Yeah.
Okay. I think if you look in the books, you'll find there's been arguments about this, and there are House of Lords dicta going both ways. There are cases following one line or another. But it does seem to me important that if we are being asked to recast Samco as a legal causation case, and if you're now accepting that it is important in your view that the burden is on the defendant in relation to that, then we do need to see it in a bigger picture, I think.
Yes, I mean, to be clear, my submission is that insofar as the defendant wishes to establish that the same loss would have been suffered through some other route, that is his burden. And in that regard, certainly it's right that other recent authorities include cases such as the BHP and Billiton and Dalmeen Authority in the Court of Appeal, which looked at the incidence of proof on that type of question. But as I say, I don't think I can fairly answer that submission, that question now by reference to other material that's before the court.
Thank you.
Well, you appreciate, if you're asking us to depart from what was said in BPE by this court only 3 years ago, I think, that's a pretty major issue on which we would need full submissions.
My lord, I'm not arguing that the result in BPE was wrong, because that was a case in which the development was a doomed proposition. The evidence was clear, Lord Sumption recounts that. So
no,
I'm not saying that...
You're not answering the point I'm making. Your argument obviously carries the implication that Lord Sumption's reasoning was wrong.
On this question on the burden of proof, as you'll appreciate, I am adopting his test, did the right thing cause the loss?
Yeah, and obviously an approach to which the entire panel, with which the entire panel agreed.
Yes.
Yeah.
Yes, I mean, my lord, there's no getting away from the fact that this is a troubled area of the law. Samco has created very many appellate decisions because it is a difficult decision. It's been the subject of a great deal of criticism. The law does need to be clarified in this area. Now, I've made it clear that I'm not seeking to depart from the result in any of these prior cases, but I absolutely am inviting the court to clarify what the test really is. My submission is that that's not a change of law, but a clarification of what the principle really is behind these cases, because the only coherent principle is one of sufficiency of causation. And I do say, and I'm now moving on to my submissions on application, which I was going to next, I do say that because the real test is one of sufficiency of cause, the judge's finding that the negligence was at least an effective cause of the loss was dispositive. He found that the right thing caused the loss because he said at paragraph 146 that it was the volatility to which the society was exposed because it could not apply hedge accounting that meant that it had to break the swaps. And we say that that was a finding that the loss fell within the scope of Thornton's duty. Nothing further had to be proved. By his cross appeal, Mr. Salcedo seeks to challenge that conclusion. He's right to do so in the sense that we say that's the finding he'd need to disturb in order for the judgment, the Court of Appeal's judgment, to be right. But there is no reason whatever to interfere with Mr. Justice Tear's findings in this regard. Questions of effective cause are ones of mixed law and fact. The judge directed himself correctly, both the common sense test and the sufficiency of cause test. And he held, having had 17 days of evidence and submissions, that MBS had proved sufficiency of cause. When he came on to deal with contributory negligence in paragraph 263, he characterised Grant Thornton's negligence as pervasive and compelling. Moreover, in order to be for the judgment to be wrong on effective cause, remember that the court would have to conclude that Grant Thornton's negligence was not even an effective cause of the loss. And in our submission, that is an unreal position. On any view, its advice was seriously wrong, repeated on numerous occasions, and critical to the decision to enter and pursue the business model. So my primary point is that the judge was right on effective causation, That's the test, and that's the answer. Now, next, my lords, we say that there was no need in this case to reach for the Samco toolbox because the facts neither required it nor were susceptible to that analysis. It wasn't required because the sole reason why the business model had to be dismantled, the sole reason, therefore, that the loss was triggered, was that hedge accounting was unavailable. In that regard, the case is equivalent to the valuer having caused the insolvency of the buyer in Samco. Causation was straightforward. Effective cause was straightforward. It wasn't apposite, it wasn't a useful tool in this case. First, because the advice and information distinction wasn't one that can be applied to the bundle of obligations that Grant Thornton admittedly owned as auditors and advisors, and its breaches of duties in that regard. Secondly, the question, what position would the society have been in if the information had been correct, is virtually unintelligible here, given that Grant Thornton were admittedly in breach of audit obligations to report and to carry out work competently, as well as to advise on hedge accounting. Thirdly, in the corollary of the last point, Samco can be useful where a claimant has entered into a single identifiable transaction following a single negligent piece of advice referable to that transaction. That's not this case. You have my submission that one can't even identify what the transaction is here. So this wasn't a case in which the Samco cap shed light on the analysis. It overcomplicated and confused it. And I do want to come back to the point that my case here is at heart very, very simple. The society was advised by Grant Thornton that it could apply hedge accounting. It relied on that advice when buying swaps and buying mortgages. When it turned out that that advice was wrong, it suffered a loss exiting the business model. It had to sell the swaps when it wouldn't have done if the advice had been correct. And it didn't recoup its losses from the mortgages because the business model had come to an end. Tomorrow never came. It's not a complicated case. The judge was right to find effective cause and he found reasonable foreseeability. Now, my fallback narrow case is one that applies the Samco analysis. If necessary, we say this was an advice case in the sense that the society put themselves in the hands of Grant Thornton in relation to whether they should apply hedge accounting or not. That's the language of the Giambroni case. And there was a duty to report that hedge accounting could not be applied. That's the Anico analysis. I'm not suggesting that that's a particularly natural analysis, but the point is that this case doesn't fit easily into an information or advice divide, and the information analysis is patently too narrow. If I'm wrong about all of that, and this was an information case, then the loss passes the test, because if the information had been correct, the society would not have had to dismantle the business model. It would not have paid out that money at that point in time, the check for 32.7 million in June. We say that the society did not have to go on and prove the ultimate outcome of the business model years hence. That was for Grant Thornton. Grant Thornton did not seek to take on the burden of proving what the position would have been if its advice had been correct. It's not good enough for it to say that the MTM losses are an estimate of what would have been paid in future under the swaps. That's the equivalent of the BTI dividends argument, and it ignores the assets that the society would have acquired in future had the advice been correct. One can well see why Grant Thornton did not seek to go down that avenue. if its advice had been correct, hedge accounting would have been effective throughout the duration of the swaps. Paragraph 15 of Mr. Justice Tear's judgment says that effectiveness advice meant throughout the duration of the derivative, the swap. So in a world where Grant Thornton's advice was correct, the swaps and the mortgages had to be matched within an 80 to 125% variance. And one can see from that table at paragraph 31.11 of my submissions that the relationship had in fact been highly effective to that point. My lords, might I just have subject to any questions, might I just have one moment to check with my juniors whether there are any further points I should raise with you? Thank you. So unless there are any questions which the panel have, those are my submissions. Lord Hodge.
You have said on a number of occasions that the exercise did fail to take account of other elements in the diagram, namely the value of the mortgages.
Yep.
But we know the value of the capital value of the mortgages from paragraph 120 of the judge's judgment.
Yes.
It's sold at a small premium over par. So yes. Does your point simply relate to the fact that you weren't able to stay in the market and get substitute mortgages, or have you anything to say about the circumstances of paragraph 120?
Paragraph 120, and first of all, I apologise, I should have come back to this in answer to your question. I meant to do so after lunch. Paragraph 120 records that the UK book was sold at par value, reflecting the rolled up interest plus a small premium. There was also a Spanish book, which the Society still holds. So the result is not yet known on the Spanish book. And in addition, my lord, you're quite right that the inquiry doesn't take into account the mortgages that would have been acquired in future under that expectation of substitution, which formed the basis of Grant Thornton's advice. I can also apologise to Lord Leggett for failing to come back after lunch too on his question about the quantification of other losses. There was a small gain by but there would have been a small gain had the 3 existing swaps been closed out in April 2006. And the judge's finding about that was at paragraph 212 of the judgment. So that added to the loss. And more generally, as I alluded to in my submissions, the judge did make findings in relation to each element of the pluses and minuses that existed at the time of the trial.
What concerns me at the moment is that on the hedge accounting, the UK mortgage book should have increased considerably in value over par at the time it was sold, but it didn't.
I think that may be a misunderstanding of what it's meant. The par value is explained in the judgment as the rolled up interest. Which is so the society was, yes, so the society received its interest at 6.8%.
For what period?
For the period to the date of the sale. That's what paragraph 120 is saying, plus a small premium.
Plus a small premium. But what I'm saying is the small premium didn't reflect the added value that hedge accounting was attributing to the future holding of those mortgages.
Well, the sale of the mortgages came about for exactly the same reason as the breaking of the swaps, that the business model had to be dismantled because it was unsustainable once it was appreciated that hedge accounting couldn't be applied. So in a world in which the advice is correct, there is no sale of the mortgages, and it's only because the advice is incorrect that the society is exposed to whatever may be the net position on the swaps and the mortgages then held.
I understand that argument, but is it not strange that the hedge accounting exercise appears to have been divorced from the market reality at the time of the sale of the mortgages?
Well, my lord, you may there be pointing to precisely why the advice was not just negligent, but really badly negligent, and the subject of a misconduct finding. If one stands back, it's obvious that there's not an effective match between a book of 50-year swaps and a book of lifetime mortgages. You only achieve the effectiveness by putting in notional dates for the expiry of the mortgages, as Grant Thornton did in its accounting. So, yes, the accounting position may have been divorced from reality, but that's why Grant Thornton is negligent and is not divorced from reality in a world where its advice is correct. And yes, it may be said that my clients were unwise in entering into the 50-year swaps. The judge did think that, and that's why he imposed a deduction of 50% for contributory negligence. And that conclusion, my lord, well, that's the fair result in this case. Yeah, that's the just and fair result. Yeah.
Thank you.
Lord Reed is muted and I think speaking. Is it possible to unmute him?
Thank you. As you may have gathered from that last problem, I'm having a number of technical difficulties with my IT connection. So before we turn to Mr. Salcedo, first of all, thank you, Ms. Secretary Chair, for your suggestions. Before we turn to Mr. Salcedo, I'd like us to adjourn for 5 minutes to see if the IT engineers can get my link to this video conference sorted out. So we'll resume in 5 minutes' time. We turn now to counsel for Grant Thornton. That's Mr. Simon Salcedo, QC. Mr. Salcedo.
My lord. No, I seem to have an echo. No, good. Your lordships and your ladyship have our written case, which I maintain in full. A point we made at the start of our written case is that the way the appellant's case was put in writing made it clear that this appeal does not turn on any point of law, but only on the proper analysis of the facts. And my learned friend attempted to dispel that notion today by advancing what she called her broad case, that there's no such thing as scope of duty as an additional filter, which I accept as a point of law, and by going back on the previous position that no earlier decisions of this court were being challenged, by challenging what Lord Sumption had said with the agreement of the whole court on the question of burden of proof. Nevertheless, this does remain an appeal, I'm afraid, on the facts. The Society's case on the facts is unintentionally, of course, seriously misleading. I have to put that right. The facts are also important because even if my learned friend were right about the law being different from what we've all understood since Samco was decided in 1996, that would not make any difference on the facts of this particular case. As she has reminded you, we've always maintained a respondent's notice point that the judge should have held that the claim failed on legal causation, and the same would apply to any conceivable basis of asking the scope of duty question on these facts, including if one incorporates scope of duty into legal causation. On some facts it might make a difference, but not on these. And after making just one further introductory remark, what I propose to do is turn to the nature of the claim for loss, which will address some of the questions that have been asked by my lords, Lord Leggett and Lord Hodge, and then say something about the facts and then the law. In the course of dealing with the primary facts, I will show you some important ones which explain why this case has not been put on the Asset Co basis, contrary to what my learned friend said in answer to a question, for example, from my Lord President, and why the Court of Appeal was quite right to distinguish it from the Asset Co type of case. My Lord, the one further introductory remark I want to make is to say that we adopt in full the Court of Appeal's judgment. In particular, the decisive passage of the Court of Appeal's judgment from paragraph 80 to the end encapsulates our argument in less than 3 pages. The Court of Appeal understood and characterised the facts of this case accurately and completely so far as relevant. In that respect, one of the key points they made on the facts is that breaking a swap for its mark-to-market value is not itself a loss, because it exchanges an existing liability, a real liability, for money's worth at fair value. That's a point that my Lord the President has raised with my learned friend on a few occasions, but which in my submission she was never able to give a direct answer to. The Court of Appeal addresses the law as to scope of duty in terms that are derived directly from decisions of this court and its predecessor. And in this appeal, save for the point now raised orally about the burden of proof, no party has invited this court to depart from any of those previous decisions. Now, of course, it's open to your lordships in this court to develop the common law as you consider proper. But on the facts of this case, no explanation, refinement, or development of the scope of duty principle would lead to a different result from that reached by both courts below. The result reached by the judge after trial in this case, and endorsed unanimously by the Court of Appeal, is not an unattractive or problematic result. If there are problem cases, this is not one of them. And the short reason for that is the one that the judge gave at paragraph 179 of his judgment, which Lord Justice Hamblin endorsed and adopted in the last substantive paragraph of his judgment in the Court of Appeal. And that is, it would be a striking conclusion to reach that an accountant who advises a client as to the manner in which its business activities may be treated in its accounts has assumed responsibility for the financial consequences of those business activities. The appellant's submissions raise questions about how that might operate in other cases. But this case is encapsulated in that proposition. This case concerns a discrete piece of advice, admittedly repeated at intervals, that MBS was entitled to present certain transactions in a certain way according to certain highly technical accounting rules. The recipients of the advice, and this is critical, and it's a distinction that was, I'm afraid, elided in several points of my learned friend's submissions, but the recipients of the advice fully understood the financial and commercial implications of the transactions that they were entering into, and they entered into them for business reasons, which indeed Ms. Savinclair has continued to support as sustainable up to today. The only matter on which the claimant claims to have been led astray by my client's negligent misstatement was whether the accounting presentation that they wanted to use was permissible under the rules. And we can see that, for example, your lordships were shown the re-amended particulars of claim by my learned friend, and we can see how she put reliance at page 503, where we see a slightly later paragraph of the particulars of claim, the ones we were showing, paragraph 73. The way reliance and causation is put is that by reason of Grant Thornton's breaches of duty, in reliance on Grant Thornton's advice and audits, the Society believed from the 11th of April 2006 onwards that it was able to apply hedge accounting pursuant to IAS 39 in relation to its portfolios of fixed rate and lifetime mortgages and swap agreements. And when the financial statements were prepared and audited, the Society believed they gave a true and fair view of its financial position in accordance with IFRS. And that's right, but what would not be right would be any suggestion, and this is where there was an elision, which is critical on scope of duty, any suggestion that the Society has ever argued that it did not understand its actual commercial financial position. Now, my lords, the first thing I want to then do is to show your lordship the nature of the claim for loss, because there has been a a bit of a seesawing, a bit of a facing of two ways in the claimant's case on this appeal as to whether what they are claiming is the net position arrived at as a result of all their business, and saying that that net position was worse for some reason to do with Grant Thornton's negligence, or whether what they are claiming is simply the break costs, which were a loss at the moment that they had to pay them and they wouldn't otherwise have had to pay them. And so it's important, I think, to look at what their heads of loss were. And before we do that, it's worth looking at the appellant's written case, which, if you've got the hard copy of the key documents, is tab 2, but it's page 60, and also page 60 on the electronic. And if you look at page 60, footnote 68 of the appellant's written case says this: "It is instructive to note that the position would have been different if what the society were doing was complaining that the entire lifetime mortgages business had gone bad and that it was entitled to hold Grant Thornton liable for losses in respect of that whole business, on the basis that it only entered the venture as a result of the negligent advice about hedge accounting. A claim of that kind would have raised the classic Samco inquiry and preclude recovery for commercial losses that would have been made in any event, even if hedge accounting could have been used. That is not the claim that the society makes in these proceedings, which is only for the costs of being required to terminate a business that it would otherwise have continued to pursue, that premature termination being the direct and immediate consequence of the negligence." And they say something similar, my lords, on the next page, 61, paragraph 78.3, just the first sentence. "Third, it must be stressed that the society is not, on a proper analysis of the position, seeking to make Grant Thornton liable for all the financial consequences of its commercial activities." And my lords, my case is that the claim which is disavowed in those paragraphs is exactly the claim that is being made. And therefore, at least on the written cases, it is common ground that it raises what my learned friends call the classic Samco inquiry. On this appeal, we're focusing on just one part of the loss that the society claims to have suffered as a result of its disastrous investment in lifetime mortgages. But there was no doubt in trial that they were indeed claiming for the losses in respect of that whole business, their phrase in footnote 68, and for the financial consequences of its commercial activities, as they put it in paragraph 78.3. And if we go to the judgment at page 163 of our bundle, it's tab 8 if you've got the hard copy of the core document, above paragraph 122, we see the first head of loss that's considered is the cost of breaking the swaps. And the judge records at 122 that the actual amount paid to break the swaps was not in dispute, but there was a dispute about the part of that payment which was transactional penalty costs. And so there are two components within the payment, and there was a great deal of expert evidence on the subject of how much of the payments was actually the transactional penalty costs for breaking early and how much was the mark-to-market value. And the judge resolved that dispute. Grant Thornton have paid, under the judgment, the transaction costs, the amount charged by the banks for breaking early, and Grant Thornton accept and always accepted that on the findings of the judge, they would fall within the scope of the relevant duty of care. So the amount of the break costs, which was the specific cost of breaking them early, rather than continuing with them or breaking at some other time, those are within the scope of the duty, and Grant Thornton have paid them. But the mark-to-market fair value loss on the swaps is a different matter. That was simply the loss attributable to holding a position which had declined in value owing to movements in the market. It was suffered whether or not the swaps were broken, and there's no basis for a finding that it would not have been suffered if the swaps had been broken later or even never. The risk that that loss would occur, just looking at that one in isolation, the risk that that loss would occur is the risk that the society knowingly took, and which had no direct relationship with the accounting advice that they received from Grant Thornton. If we then go on, we have to go on quite a few paragraphs, because this being the main head, the judge considers it at some length. That's not a criticism. He considers the scope of duty argument. But if we go on in the bundle to page 184, we get to subheading 2, which is the second head of loss. The second head of loss, considered by the judge, was the gain that the society would have made if it had closed out the swaps that it had already taken prior to any advice from Grant Thornton in 2006. So the society began its course of lending or buying long-term mortgages and hedging them with long-term swaps before any negligent advice was received. And the society established at trial that if Grant Thornton had given competent advice that it should have given, then the society would have broken the swaps it already had, but would have kept the long-term mortgages, which were worth £21 million. And they're sometimes called the £21 million book, just to identify them as the ones that had already been written by 2006. But it would not have written any more long-term mortgages. So the second head of loss is this. At 2006, the swaps were in the money. As it happened, interest rates had risen since they'd been taken out. So had the society broken the swaps then, it would have made a gain. And they claimed that lost gain from Grant Thornton. The judge rejected it on the basis of scope of duty. He said it was consistent with his finding that the mark-to-market costs were outside the scope of duty, that so were the mark-to-market gains that could have been made in 2006. That finding has not been appealed. So it seems to be common ground that the judge was right, that gain, lost gain, fell outside the scope of duty, and we would endorse that. Obviously, it did. Then, my lords, at paragraph 214, we start on the third head of loss. And the third head of loss was, it was suggested that the society would have made more profits had it held on to the £21 million book after 2013, instead of selling them as it actually did. So in 2013, as you've heard, they had to break the swaps. They sought to sell their existing mortgage books. Now, the mortgage book taken on after 2006 is not in this category because on their case, that would never have been taken on. But the 21 million that they'd already taken on, their case was they would have kept that. The judge agreed with that. And they would have therefore had it not just up to 2013, but forever after. What happened in 2013 was that the whole UK book was sold for a fair market value. And the society never contended anything else. This was never a forced sale. It was never a sale into a market that wasn't a proper market. It was sold at fair market value. And on the next page, at page 185, paragraph 216, the judge, after having heard expert evidence that was disputed on the subject of whether there was a loss from selling this book at fair market value, held at paragraph 216, halfway through the paragraph, the claimant chose to sell the book and recovered its market value, which it used to improve its capital position. The sale price must have reflected the then present value of the right to receive future income from the book. To award damages in circumstances where it's already received and made use of the market value of the book would overcompensate the claimant. So that's the direct answer to the question I think asked this morning by my Lord Hodge, was that the future income on the 21 million book was in fact received by the society in 2013. And then on page 186, we see the fourth head of loss, which was the cost of hedging the mortgages that had already been acquired by 2006. In other words, this was the payments made between 2006 and 2013 on the swaps which hedged the 21 million book, which would, on the society's case, have been broken in 2006. There's a claim for 2.55 million for the net payments that the society actually made on those swaps, the sort of half-yearly payments that your lordships and my lady were shown by my learned friend on the swap confirm itself. This claim was rejected on scope of duty grounds. There's been no appeal. It must now be common ground before your lordships and your ladyship that this head fell outside of the scope of duty because it was simply one of the costs of the business. On the same page, we see that the fifth head of loss was some restructuring and advisory costs on the termination. And Grant Thornton did not dispute that on the basis of the judge's findings, it would be liable as far as scope of duty was concerned for such incremental restructuring and advisory costs as could be made out. They are traversed paragraphs 223 to 232 of the judgment, taking us on to page 188. 188, the sixth head of loss, is similar to the fifth. There was a question about how much of those fees were really to do with the restructuring. So all of those were matters which we accepted were within the scope of duty and which we have now paid. If you then go to page 188, the seventh head of loss was the setup and operational costs of the Spanish mortgages. That again was a claim for losses in respect to the whole business. Again, it was rightly rejected by the judge on the same scope of duty grounds, and again, there has been no appeal. Then at heads 8 and 9 on page 189, the last two heads of loss were credits, in fact, for the society's profits from holding the mortgages, which the judge rejected on scope of duty grounds. And this perhaps goes to a point my learned friend made about the necessary symmetry. And we accept that if we're right about scope of duty, then we don't get those credits. It is symmetrical. But we do make the point, this is a point made in the footnote on the very last page of our written case, that if your lordships are against us on the appeal, then we should get those credits. Because if you reverse the judge's, the Court of Appeal's approach to scope of duty, then these are credits that go with the whole business. So, my lords, my lady, the claim at trial was a claim for losses in respect of the whole business. That's exactly what it was. The judge analysed them into those which fell within and those which fell without Grant Thornton's scope of duty on the basis of their actual breaches of duty. And based on the paragraphs from the written case that I showed the court, it seems to be common ground that on that footing, that was actually the right approach for the judge to apply the classic Samco analysis. And it now seems to be common ground that heads of loss 2, 4, and 7 fell outside the scope of duty on the basis of that analysis. My lords, my lady, if you ask the question, what's the difference between heads of loss 2, 4, and 7 and the head of loss that remains an issue in this appeal, the answer is there is no difference of principle whatsoever. There's only a difference of amount. And the one thing the society has always been very clear on, and I'll explain what I mean by this in a moment, is that it wanted the full amount. The only real dispute between us on this appeal seems to be whether the correct characterization, well, certainly the only dispute on the written documents anyway, appeared to be whether the correct characterization of the mark-to-market losses on the swaps is that their costs of premature termination, as my learned friends say, or they're just another set of market losses from the transaction, as we, Mr. Justice Tier, and the unanimous Court of Appeal all say. My lords, what I intend to cover on the facts, that was my sort of introduction to the heads of the claim. What I intend to cover on the facts are some primary facts about the mortgages and the swaps, mostly taken from the judgment. And then I want to deal with the factual issue, whether the business was viable and sustainable, as the appellant contends. And in dealing with the primary facts, I think when I get to the end of that, I'm going to seek to address the question of why this is not an asset co type of case. So, my lords, the primary facts that I want to draw attention to, if I may, starting with what we can get out of the judgment, which is most of it. If we start, well, one probably don't need to look at this, but the UK lifetime mortgages were acquired between December 2004 and October 2008. That's paragraph 6 and 9 at page 135, also paragraph 78. The Spanish mortgages were acquired from 2008. That's paragraph 10 at page 135. No more lifetime mortgages were acquired or written after 2009. On the 2nd of June 2009, it's recorded in the chronology entry at page 20, the agreed chronology, that the FSA placed a penal capital add-on in respect of the lifetime mortgages. The FSA, as I'll show you later, really didn't like this business at all. And after that, no more were written. The judge noted, and perhaps now we're going to places I should invite you to look at, page 157 in the judgment, paragraph 103. the judge noted that on the 17th of June 2009, Mr. Cowie is the chief executive of the society. He was the chief executive throughout the relevant period. He did not give evidence at the trial. I think he had ceased to be chief executive after 2000 or in 2013, but he was the chief executive right through to 2013. He told the regulator in the response referred to at 103 that it was appropriate to reduce the proportion of lifetime mortgages in the total book to 15%, and that the society had no further appetite to extend the portfolio. So the lifetime mortgage business had entered runoff by June 2009. The next paragraph of the judgment, 104, in 2010, going on to the next page, the society told the regulator that it would reduce the proportion down to 10%. Then going on to paragraph 109 at the foot of 158, in June 2012, the FSA sent an even more demanding letter, which about 4 lines up from the bottom of the paragraph on the page, Mr. Worsnip, the claimant's regulatory capital expert, accepted that this letter represented a demand by the FSA for action now. And that's action in the sense of, he says, a greater understanding of risk, an increased focus on how the capital requirements would be met. But in context, it meant an increased focus on reducing the lifetime mortgages. We see then that in the next paragraph, 110, on the next page, that the claimant resolved to sell £18 million worth of lifetime mortgages. We're in 2012 now. To do that without breaking the swaps, which were heavily out of the money, it tried to issue new fixed rate mortgages that weren't lifetime mortgages. But that turned out to be very, very difficult. And in paragraph 110, the judge records that in practice it was, they could only issue very few, and it was very, very few. And ultimately, the judge records in paragraph 110, they sold only £4.8 million worth of the lifetime mortgages against their target of reducing them by 18 million. And most of those were not replaced by new fixed rate mortgages. They actually couldn't even get away that number of fixed rate mortgages. Mr. Justice Tier then sets out at paragraph 112 on page 159, over 2 pages of the judgment, an important letter from the FSA of the 16th January 2013. I'm going to look at this, if I may, in more detail shortly. But in summary, the FSA's concerns about the lifetime mortgage book were even stronger by January 2013. We go on then to page 161, paragraph 114. The judge records that the chief executive, Mr. Cowie, prepared a memo in response to that letter, which made it clear to the board, and if we look at the quote in the paragraph 114, he made it clear to the board that the main way to reduce the scalar that the FSA had imposed on the company's capital requirement was, in his words, the staged sale of UK lifetime loans. So that was where they were at the beginning of 2013. And this part of the story is summarized by the judge at paragraph 184, page 178, and paragraph 184 at page 178, the judge concludes that it's likely that some of the lifetime mortgage business would have been sold, even if the problem of hedge accounting had not been discovered. And that final finding is not controversial in this appeal. It's reflected in the agreed facts, paragraph 23 at page 9. That was what I wanted to tell your lordships about the primary facts about the mortgages. I now want to refer to the primary facts about the swaps. Now, Grant Thornton did not advise on entering the swaps and mortgages. That was all done for commercial reasons. The mortgages were thought to be a good business. The swaps were thought to be a good way of hedging them. But it also included the reason that the society took out longer term swaps was because they took a view about long-term interest rates. And that's not controversial on this appeal. It's reflected in the agreed facts. paragraph 15, page 7. We also give some more references to it at paragraph 30 of our written case at page 80. The board knew that they were over-hedging in the sense that the length of the swaps greatly exceeded the average expected length of the mortgages. And that's finding at paragraph 76 of the judgment at page 150. And this is obviously a very important fact, that the board knew it. There were documents, including the note from the treasurer, which is quoted at paragraph 76 of the judgment at page 150, that they knew that the mortgages would not last 50 years. 20 years might be more appropriate, in the words of the treasurer in his note, but 20 years swap rates were higher than those of 50 years. So that meant, of course, the market was expecting that interest rates would fall between years 21 and 50, and it was prepared to offer better terms for those swaps. The board took the view that that was not likely to happen, and that therefore longer term swaps were a good idea. Now, I think I've just about got time to show your lordships one of the critical ways in which there is an illusion between the accounting treatment and the commercial reality in my learned friend's case. My learned friend took you today to page 643 of the bundle, and I'd like to take you back there. And this page, as my learned friend, I think explained, certainly what she said was consistent with this, shows you in a way how the accounting was done in a way that, in a sense, makes no sense. So this, as you can see, is a schedule produced somewhere within the Manchester Building Society accounting department with a few manuscript marks on from an auditor. And as my learned friend said, it's a list of mortgages. And on the right, there's a column with the date that the fixed rate period ends. And that date is far too late. Nobody knew the date the mortgages would end, but nobody expected they'd last that long. And the dates were selected by the Society's finance department to match the dates of the swaps that those mortgages were matched against. And as Ms. Savinclair rightly told you, an auditor exercising all reasonable care and skill would not have accepted this schedule, because they would have realised that inserting the end date inserted for the mortgages were actually the end dates for the swaps. I mean, one might forgive perhaps the individual auditor who didn't notice that, but nevertheless, that was negligent auditing. And in other words, what this schedule represented was the business plan that my learned friends have been pressing on your lordship. It represented the idea that there would be a mortgage to set against each swap for the whole lifetime of the swap. So it didn't really matter whether that was the mortgages that already existed or some unknown later mortgage. And therefore, to make them match, to create the effectiveness, what you did was you pretended that the mortgages you already had would last as long as the swaps. So that's what they did in order to create the effectiveness and pass the test. Now, what my learned friend suggested in relation to this aspect was that she said, if you do have to ask the Samco counterfactual question, what would have happened if Manchester Building Society's advice would have been true? She said, you have to assume that the hedges were actually effective. That's completely wrong. And the reason it's wrong shows why the Samco counterfactual test is so effective at actually dividing up what is within the scope of the duty and what is not. The Society knew that this was how it was achieving apparent effectiveness. The question they asked Grant Thornton was, is this allowed within the rules? And Grant Thornton's mistake was to tell them it was allowed within the rules. It was never alleged, could never have been alleged, but it certainly was never alleged that anyone at the Society was misled into thinking that the swaps were commercially effective. They were misled into thinking that they met the effectiveness test under the rules, because they were misled into thinking that it was acceptable to do what they were doing here, which is using the end date of the swap on the end date of the mortgage, on the underlying and unspoken assumption that some other mortgage would come into this schedule before the end of the swap. So the correct counterfactual only assumes that Grant Thornton's actual advice was correct. It does not assume that every possible consequence one might take from that advice was correct, unless that consequence was taken and was part of the negligence. So the correct counterfactual is that the hedge accounting rules did permit this kind of approach to be used. That's the counterfactual. That the hedge accounting rules under the relevant international accounting standard did permit an entity that had a plan to write more mortgages in the future to pretend that the mortgages it had went for the length of the swap. And that is a counterfactual about the content of the accounting rules, not commercial reality. And that perfectly reflects the negligence that was proved against Grant Thornton and the true state of knowledge of the society. And it therefore shows you exactly why it is that the Samco test works, and certainly works in this case. My lords, I see the time, and I've got some related points to make, but I'm very happy to make those in the morning.
Thank you very much, Mr. Salcedo. Just while we have that page in front of us, is the implication of what you're saying that the dates we see in the right-hand column under date fixed rate period ends are fictitious dates that have been assigned to each of these mortgages in order to match the date of the expiry of the swap, which is designed to hedge against the risk involved in that mortgage?
Yes, fictitious might be putting it slightly too high, because they are the dates of the swap's end, but these are lifetime mortgages, so nobody knew what date they would end. They're not for a fixed term. But as that note from the Treasurer that I showed you in the judgment sets out, the expectation was that on average these might last for 20 years.
Yes.
But they're matched against swaps that lasted for much longer. So yes, those dates are not the end dates of the mortgages, they're the end dates of the swaps. And that is the fundamental mistake in all this.
Yes. Yes, I see. And yeah. And obviously it was the mortgages that had fixed rates. The swap agreements, were dependent on at a fixed rate paid out and a variable rate coming in.
Exactly so, my lord. And that's the point of my lady friend's famous diagram, is that they have a fixed rate in on the mortgage and then out on the swap, and then a LIBOR coming in on the swap.
Yeah. Thank you for clarifying that. Well, in that case, we'll adjourn now for the day and resume at 10:30 tomorrow morning. Thank you very much.
My lord.